Hello everybody, this is Aishley Verma, an intern with LEXIS and Company, and today in this video I will be dealing with a case named Sonu versus Sonu Yadav. So the citation of the case is Criminal Appeal number 377 of 2021 arising out of SLP CRL number 924 of 2021. It was appealed in the Supreme Court of India under Criminal Appellate Jurisdiction. The bench consists of Dhananjay Y. Chandrachud, Justice, and Justice M.R. Shah. The date of the judgment is 5th April 2021, and the head notes of the case include Section 498A and Section 304B of Indian Penal Code and Section 3 and 4 of Dowry Prohibition Act 1861 and Section 439 of CRPC. Facts of the case includes the following. So the FIR, that is First Information Report, FIR number 0076 of 2019, was registered on 9th February 2019 at the police station Friends Colony, District Etawah, for the offence under Section 498A and 304B of the Indian Penal Code and Section 3 and Section 4 of the Dowry Prohibition Act 1861. The FIR was registered on the complaint of appellant, who is the brother of the deceased. The marriage between the deceased and the first respondent was solemnized on 5th July 2018. It has been alleged in the FIR that for the first, at the time of the marriage, a cash amount of rupees 15 lakh, a motor vehicle and other household items were provided in dowry. It has been also alleged that the FIR, that the first respondent and his parents were not satisfied with the amount of dowry, and an additional amount of rupees 5 lakh was demanded from the respondent. On 8th February 2019, it has been alleged that about 8:45 p.m. in the evening, a phone call was received from a cell phone from the first respondent, when the appellant was informed that if he wished to see his sister alive, an amount of rupees 5 lakh should be arranged, and the phone call was then disconnected. However, at 1:30 a.m. in the morning, on 9th February 2019, the appellant received the phone call requiring him to take away the dead body of his sister. The FIR records that the appellant, together with the members of the family, went to Etawah and found that the matrimonial home of the appellant's sister was locked. They came to know that the dead body had been kept in the district hospital. On these allegations, the first information report came to be registered at 11:49 a.m. on 9th February 2019. A charge sheet has been submitted on 3rd May 2019 for the offence alleged under Section 498A, 304B of the IPC and Section 3 and Section 4 of Dowry Prohibition Act. The bail application filed by the first respondent was rejected by the session judge on 18 June 2019. The High Court was thereafter moved in a bail application under Section 439A of CRPC 1973. After recording the rival submissions, the High Court allowed the application. So these were the facts. If we talk about the issues, so there were 3 issues that was involved in the case, and these issues are following. So the first issue is it justified for the High Court to grant a bail at the present stage? The second issue is there an actual demand of dowry? And the third issue is the FIR regarding the harassment suffered by the deceased near her death over demand of dowry by the accused? So was it the harassment that led to the death of the deceased? So now we have the judgment. So the judgment held by the court are as follows. Suffering from the severe headache and mental disturbance since the past 9 months. So this was a quotation in the FIR, which was in the application which was submitted by the respondent. So and that she has taken to a doctor by the first respondent. A copy of the medical prescription which has been submitted before this court would be prima facie indicating that there was no serious alignment. So it is hence proved that there was no mental illness of the deceased. Further, for the above reason, we that is the bench are of the view that the order of the High Court granting the bail without due application of mind to the relevant facts and circumstances as well as to the provisions of this law requires the interference of this court. So that is the reason why it was appealed in the Supreme Court, because the High Court didn't use its mind. Lastly, we, the bench, accordingly allow the appeal and set aside the impugnant judgment of and the order of the single judge of the Allahabad High Court dated on 1st December 2020, granting the bail to the first respondent. Sorry. Also, the grant of bail to the first respondent shall accordingly set aside, and the first respondent shall surrender forthwith. Further, we, that is the court, however, clarify that the observation obtained in the present order are confined to the issues of bail and shall not affect the merits of the trial. Also, the pending application, if any, set disposed of. So this was it. Hope you liked the video. Thank you so much.